Good evening. For my final video this evening, I want to discuss the governor's emergency powers as they pertain to condominium associations. In my prior video, I spoke about homeowners association. This is about condominium associations. So first of all, for those of you who did not see that other video, on March 9th of this year, the governor issued an executive order number 20-52 where he declared a state of emergency, and I can provide a link for that on our website. With respect to that state of emergency, what the governor did was effectively evoke, where it comes to homeowners associations, in this case a condominium association, the powers under Chapter 718, specifically Section 718.1265. Now, normally this was evoked, or these powers were evoked and meant for hurricane situations, but in this case, we believe that some of these powers, as I've discussed earlier today with my recommendations, can be effective when dealing with a condominium association. So without reading all of 718.1265, an association emergency powers, I want to go over the important ones that I believe are relevant. First of all, the board can conduct board meetings and membership meetings with notice given as is practical. Such notice may be in any practicable manner, including publication, radio, United States mail, the internet, public service announcements, and conspicuous posting on the condominium property, or any other means the board deems reasonable under the circumstances. Moreover, notice of board decisions may be communicated in the same manner. Now, I've talked about this morning. We want to make sure that you are not in a position to harm yourself by getting infected from others or infecting others. So we have already opined that boards can conduct meetings over email, over the phone, ratify those actions later. We certainly do not want the associations to stop functioning, to stop paying their obligations to their vendors, to stop providing services that the community is used to and desires to continue to have. On the other hand, as I said earlier today, if there's nothing of the board to conduct, or an election is upcoming and either you have enough seats to fill those vacancies and there are not more applicants running than vacancies permitted, then you can reschedule those meetings. I've already suggested that when you do reschedule those meetings, it doesn't open them up again for people to have an opportunity to come in and now decide to run for the board. If that's already closed, then you continue being closed and you move forward with those people who were previous applicants. And I'm talking both in circumstances where there were the same number of people running as seats available, and even where it's a contested election. That part is closed. You would just reschedule it 30, 40, 45 days down the road. The association has the power to name as assistant officer persons who are not directors, which assistant officers shall have the same authority as the executive officer to whom they are assistant during the state of emergency to accommodate the incapacity or unavailability of another officer of the association. This basically means that if you have residents that are out of state, unable to come back, want to tend to a second home or their primary home, and this is their secondary condo or secondary residence, then you can, if needed, appoint other members in the community to help serve on the board and on their behalf. This is a temporary service until they're able to come and fulfill their duties and obligations of the community, and it's simply intended so that not one or two remaining board members are tasked with the rest of the association's obligations. The association can implement a disaster plan before or immediately following the event for which a state of emergency is declared, and can shut down elevators, electricity, water, sewer, or security systems, or air conditioners. Again, these are all health, welfare, and safety issues. You need to consult not only the board members, but you should consult your management company, and I suggest legal counsel. Obviously, you want to do things that do not threaten further injury, health, welfare, or safety issues to your members, their guests, and invitees, But on the other hand, you may want to shut down, as I mentioned earlier today, portions of the association's property where people otherwise are congregating or would normally congregate. Meeting rooms, gyms, movie rooms, so forth. Pools, open areas, again, I suggested earlier that the association, and again, it's under the statute as well, can determine that any portion of the condominium property unavailable for entry or occupancy by unit owners, family members, tenants, guests, agents, or invitees to protect the health, safety, and welfare of such persons. Again, pools, while they're large and most often can provide for that social distancing that's been recommended at 6 feet, sometimes the play systems in the communities are more dangerous, where you don't know if they're being cleaned off on a consistent basis by those who are using it. Certainly the association wants to and should put up signs and notices that it is not in the business of being able to clean on a consistent basis, much less at all, these areas from potential virus and disinfecting them. The association has limited funds, limited personnel, and everyone who uses these facilities is using them at their own risk. This should be posted. I suggest posting it in multiple languages if you have multiple owners, guests, invitees that speak other languages other than English. This is a very important issue, and everyone should be on notice as reasonably as possible. Again, the statute provides, and there are other portions of the statute that I don't think are relevant, that based upon advice of emergency management officials or upon advice of licensed professional retained by the association can determine whether the condominium property can be safely inhabited or occupied. I would limit that, of course, to what we've been talking about earlier today and now: meeting areas, closed areas that are common, gyms, movie areas, so on and so, TV rooms, so on and so forth. I do not believe that the association should enact any power unless there's a different issue involved, which is the breach of the structure to limit somebody occupying their own property. The association has the power to mitigate damage, to contract on behalf of any unit owner or owners for items or services which the owners are otherwise individually responsible for, to prevent further damage. The association can clean units out if necessary, can replace and fix items that are broken within those units. Again, these get into issues and realms that may be above and beyond most associations' financial abilities and circumstances that really affect the owners. I am not suggesting, nor are we suggesting, that any association become obligated to go into unit owners' buildings, units, and clean or otherwise disinfect those units. There might be circumstances, and these really should be discussed on a case-by-case basis, where you may have hoarders or other people who you know are not being clean, who may pose a risk or a danger to the rest of the community. Those issues should be addressed on a case-by-case basis, and perhaps the association may want to consider some type of self-help remedy. Again, self-help remedies have a whole mess of problems associated with them, and you need to also look to see if your documents have that power. You do have it under these emergency powers, but they are limited and should be discussed, again, specific circumstances with specific application. Finally, I want to talk about something that unfortunately may arise in these cases now, and that's not so much of the virus, but the effect of shutting down so many of our local businesses and having so many people out of work. We are anticipating, unfortunately, a large rise in collections and foreclosures. I'm going to suggest that the association do its best to work with its owners and those who are unable to pay because of a loss of job on some type of payment arrangement or a longer period of time to pay the current arrangement. What I do suggest is, when doing so, the association ensure that these are done in writing. So our office, for instance, would start on a collection letter. An owner would come back and say, listen, here's what's happening, here's what happened to me. It's not that I've never paid before, it's that I've been laid off because of the virus. And we would work and see what type of arrangement that owner can do to both accommodate the association's needs to continue having revenue to pay for the services that it provides all of its owners, yet being considerate in this very, very difficult time where this owner is simply been discharged because or unemployed because of a service business or some other business that's been just devastated by this pandemic. We hope that this has been informative. Please don't hesitate to contact us. As long as we are permitted to continue traveling to our office in Boca, we will be there. If it changes, we will be remote. We will offer our services as long as we can, and we don't anticipate an interruption in those services. Thank you again. Please be safe for yourselves, your families, and please don't hesitate to contact us to ask and to get advice that we're more than happy to discuss with you on a case-by-case basis should you need. Take care.